My name is Mike Blake, and I'm going to be delivering this content today on how to commercialize intellectual property. Cornelia and I are co-founders of Iceberg Strategies. We're a business valuation and strategy consulting firm. I do have a little bit of housekeeping that I do at the start of every presentation, and those are the disclaimers. Intellectual property commercialization is a complex, highly nuanced topic. We couldn't possibly cover everything there is to know about it within the span of an hour. There's nothing in this content to be construed as any kind of recommendation. Many people find themselves with accidental intellectual property. If you intentionally created intellectual property, chances are you've already thought through a path for achieving monetization. But what I found over the course of my career is that a lot of people find themselves in the possession of accidental intellectual property, which on the one hand sounds odd, but it turns out that it takes place more often than I think a lot of people realize. One case is a company will build a bespoke product for a customer. They still own that product, but the customer uses it. And then for whatever reason, the customer either moves on or goes away, but you still have that intellectual property. Experimentation sometimes leads to the creation of intellectual property. The accidental discovery of something, right? Rogaine, which is the medicine that's used to regrow hair, was actually intended to be a heart drug. Turned out it didn't help hearts at all, unless you consider growing hair in the heart to be a benefit. But the researchers noticed the side effect was that men were growing their hair back. A lot of companies now are encouraging their employees to take on side projects as a way of fostering innovation within their culture. And sometimes that unexpectedly yields intellectual property that doesn't necessarily fit into the business's strategic profile or plans. You can inherit intellectual property. Not only can you inherit intellectual property as a company, for example, you might make an acquisition and discover that there's intellectual property you did not realize existed. But individuals inherit intellectual property as well. And I've worked on a number of valuation matters where somebody inherited intellectual property from a third party, and then they needed to figure out what to do with it, if anything. Who knows? You may inherit somebody's invention or somebody's manuscript. Think about the descendants of J.R.R. Tolkien. He had many unfinished manuscripts, some of which were later compiled into a novel called The Silmarillion. That's intellectual property that was effectively inherited. Edward Gygax, who was the son of Gary Gygax, the creator of Dungeons and Dragons, inherited all kinds of intellectual property that he himself is now monetized. And finally, you find companies or people find themselves in a position of accidentally owning or needing to commercialize intellectual property because they try to sell their company, but they discover that for whatever reason they can't. But there is interest in buying the assets. And so the owners have to decide if they're willing to pivot away from selling their company, where maybe they're not gaining much interest in the marketplace, but they are finding interest in the market for individual assets. And then all of a sudden, a company sale becomes an intellectual property commercialization and monetization problem. You can't have a garage sale for intellectual property. You can't just walk out and go out with a sandwich board and say, hey, I've got intellectual property. Intellectual property is something that has to be monetized in a very intentional way, especially if it's intellectual property that you weren't necessarily expecting to find yourself owning or being in charge of. And for the most part, the material we're going to cover today is relevant for patents, trade secrets, trademarks, copyrighted material, data sets, though less, and software. There are probably other kinds of intellectual property, customer information, for example, that could fit into this specialty vendor information. But for the most part, this should cover it. And I've tried to create a set of content that can be applied to any of these categories of intellectual property so that regardless of the kind of IP that you find yourself in or are just curious about, the lessons should have a fairly high degree of applicability. So I've been working with intellectual property pretty much all my adult life. I started actually in privatization in the fall of the former Soviet Union, where I worked with on a USAID and Brown University grant, whose goal was to train entrepreneurs in how to work with the intellectual property that they inherited, often from the state, and turn those into viable businesses. And in some cases, those were companies that had to do with the defense sector. And so there's an additional challenge of trying to commercialize intellectual property that was originally developed for a defense application. And there's actually a term of art for that called defense conversion. That's something that happens in many countries where governments want to apply military technology to the private sector. And so over that 30 plus year period, I've distilled 6 laws of IP commercialization. The first is that IP commercialization costs money. And I think it's critical to understand that intellectual property, for the most part, is hard to commercialize. Yes, there are some kinds of IP that you can commercialize on a shoestring budget, but for the most part, if you find yourself with accidental intellectual property, in order to commercialize it, it's going to take some money, sometimes a substantial amount. IP commercialization carries risk. There's no law that guarantees that every attempt to commercialize intellectual property will succeed. In fact, the chances are better that it won't be successful than it will. That's why when it does succeed, it tends to pay off very handsomely. If it didn't have that return ceiling, it wouldn't be worth the risk of the exercise. But all the things that I'm telling you today, you can do everything right, you may still not succeed. IP commercialization almost always takes time. Even when you get lucky and IP goes viral, but when you find yourself with IP and it's not commercialized yet and you're trying to commercialize it, it's going to take time. And that time frame is going to be measured in months, potentially years, not days or weeks. If you do achieve commercialization in a shorter period of time, you are very much a statistical outlier. Intellectual property rarely has value in isolation. I hear a lot when I encounter people that have a brand, even a patent portfolio, and they want to commercialize. They meet the cold, harsh reality of the market. For the most part, when IP is transacted, it's successful because it operates in concert with other assets and other forces that enable it to achieve its full potential, which explains why just selling a standalone IP asset on its own is just quite difficult. Even a little bit of commercialization goes a long way. You don't have to turn into Elon Musk and build a whole car company around it, or a rocket company around it, or a flamethrower company around it, or an underground hyper subway system around it. But even a little bit of proof that there's some market traction goes a long way. IP that has value is subject to and will attract attacks. Just as there are certain people, and we all know them, who, when they go outside in the summer, they go out for a picnic, a walk, a hike, and it seems like every mosquito on the planet is attracted to them. IP can be the same way. The second you start being noticed in the marketplace, you're eating somebody's lunch, you're disrupting, you pose some kind of threat, you show some kind of opportunity, somebody's going to attack it in some way, because that's the way the market behaves. So I hope these will be useful to you, because I think they serve as a framework to understand why IP behaves the way that it does, and why the advice I give around commercialization is the way that it is. So commercialization costs money because you need to spend money for legal protection, which, by the way, is almost always imperfect. Just because you have a patent or a trade secret doesn't mean that your IP is safe. It means you have a line of defense. Let's say we have an example of somebody inheriting a formula for a drug that cures pancreatic cancer, but your background is in philosophy. You're going to need a higher expertise in order to properly commercialize that IP in some way. And finding buyers, licensees, or other partners is most likely going to cost money. You're going to need to do some research. You need to invest time. You'll probably need to retain some kind of help. Many people who find themselves with intellectual property unexpectedly, they retain a broker to help them find a home for that. Because people, of course, don't work for free. So you're going to spend money on information, on engineering support, on legal help, on people who study the market for you, and on people that actually help bring your product to market. All right, I want to offer a correction. Eric, thank you for this. Apparently, I mixed up the Rogaine story and Viagra. Rogaine was an accident of ulcer research. I stand corrected. I never mind being corrected because I'm always smarter for it. The second law of commercialization is that there's risk involved. Your IP may not work at scale. You may remember several years ago when Elon Musk launched Tesla, he could build one car, but he couldn't build a lot of cars to save his life. He couldn't meet production targets. There are all kinds of recalls and fixes. It's a testament to his personal brand that has survived the growing pains. Most people don't have Elon Musk's resources to make their intellectual property scale. It's hard to find customers. For any new venture, there's always a risk that you're not going to be able to find customers in a timely, economical manner. You may find you don't truly own the IP. I was on a call with somebody last week, actually, with somebody who thinks that they inherited intellectual property, but they may not have. And the reason is because the person's mother and her parents were divorced. His mother passed away. His mother received some intellectual property in the divorce settlement, but up to that point, the lawyers hadn't gone through all the documentation. They had not realized that in the event of the spouse's death, the IP reverted up to the ownership of the husband. So it turned out he never owned the intellectual property to begin with. IP may not be as attractive when it's exposed to the marketplace. Not only might you have difficulty finding customers, not only are you going to have difficulty because of encountering predators, but you may find the intellectual property just flat out, it doesn't work. Maybe that manuscript winds up being a flop, or maybe it's unusable because it contains cultural references or cultural dialogue that you simply could not post today. Sometimes the IP is actually replicated someplace else in the market. This happens with software. One of the hardest things about the software business is, as Eric pointed out, you may not even own the code. It may be open source, it may belong to somebody else. Commercialization takes time because finding people to be on the other end of that transaction can take months. It just takes time to identify them, build a relationship, initiate a conversation, find someone that wants to engage in the conversation, and move that conversation forward. And it's something that you can't easily rush. We all know that if you have to execute a business plan, it's rare that companies succeed right out of the gate. And you may have to raise funding to commercialize your IP, even to license it, because you may require some additional development. That process can take months to execute. And as I mentioned, even establishing that you own the IP to begin with may not be a slam dunk. There may be many degrees of separation between you and the intellectual property. And you have to follow the paper trail to make sure that it has been properly assigned to you. IP rarely has value in isolation. And the reason is because IP often relies on other assets to create value. When you have multiple assets, it makes it less likely that there'll be a single point of failure. For example, if you have some IP that's litigated, but you have a portfolio of IP, maybe one or two of the claims are struck down. But if you have 20 other claims, you may still be okay. Your IP value may survive that exercise. And it's important to understand that IP tends to hunt in packs. On the left-hand side, one IP, and I'll call it a patent for simplicity's sake, you almost never see a transaction of substance involving just one patent because patents can be invented around. One patent is more subject to challenge. On the other hand, if you have many patents that work in concert, which have claims that reinforce one another and expand the overall scope of protection, that tends to be more valuable because even if one of those IP goes away, you still have the other IP in place. In a way, it's like basic portfolio diversification theory. If you have one piece of IP, if for whatever reason that's invalidated, you may have nothing left. On the other hand, if you have a portfolio and one piece of IP is invalidated, doesn't work, goes away, in this case, you've still got 6 left. And that means there's potentially significant value that remains. Now, I think the best illustration here is why has nobody ever copied Coca-Cola? As most of you already know, Coca-Cola's formula is not a patent, it's a trade secret, and a closely guarded one. But I think with modern technology, if somebody really wanted to reverse engineer Coca-Cola's formula, they could. Somebody smart enough with mass spectroscopy and other techniques to figure out the formula or pretty well approximate it. So why has nobody done it? Why has nobody gone out there and said, we've got Mocha-Mola, right? The reason is because the Coca-Cola formula isn't worth all that much without the other assets that surround it. So I think nobody's bothered to copy the Coca-Cola formula because in isolation, frankly, it isn't worth that much. Without the brand and the trademark, without the distribution and the other things that go with it, a friend of mine likes to say IP doesn't start to have value until you start to make money with it. And I think there's some truth to that. And while IP is sold before it's been commercialized, drug candidates are a great example of that. They typically sell after they pass a successful phase 2 clinical trial in the United States. That's the sweet spot for acquisitions happen. But generally speaking, IP is much more valuable if you can take commercial risk, i.e. risk that you can make money off of it, off the table. You're demonstrating that there are customers. Even better if you're actually producing a profit. And you have to demonstrate that it provides some financial advantage over competing products. So it leads to increased market share. And if you just think about it, which of these two scenarios would you choose? Would you choose $1 billion market if there's no revenue? Or would you choose an IP that's got a $100 million market, but it's already making $1 million? It's not so obvious. Some venture capitalists might say, oh, I want the $1 billion market. The $1 million doesn't mean that much to me. But venture capitalists, most of them will tell you they're investing in management teams, ideas, stories, but they're not investing in as much in core technology. The second you present IP that is generating value, someone's going to attack it. The sad fact of the matter is that large infringers, if you're a small company, will take your technology, they can copy it, and they'll simply dare you to sue. I'm not going to mention any names, but they'll be in a room with a large tech company and they'll say, yeah, we're probably infringing, sue us. Do you have $5 million to sue us? Do you have 5 years to pursue this, including the appeals process? And it's really crappy. And it's a part of our IP system that I wish would change, but wishing it would change doesn't make it change. So we have to operate in the environment that we have. Infringers tend to ask for forgiveness rather than permission. Yeah, there's the odd infringer that will own up saying, hey, we're infringing, we want to work out a deal. Most of the time they'll realize that they know darn well they're infringing and they're just hoping you're not going to call them on it. And to the extent possible, assuming that your competitors care about the IP at all, they will try to invent or code or design around your intellectual property. And they'll do that for 2 reasons. Number one, they'll do it to avoid possible conflicts or possible infringement accusations. But they'll also do it because in the event that there's some sort of trial that takes place, if they can make something that's relatively similar, then they're going to argue that your intellectual property was effectively obvious and therefore never existed at all. So companies have an established playbook for circumventing intellectual property. They'll hire people away from companies in order to get their trade secret knowledge. Happens all the time, happens in American football, where if the San Francisco 49ers are playing the Kansas City Chiefs the next week, and the Chiefs released somebody 2 weeks ago, then they will hire them and bring them onto the practice squad, hope to get some insights into their play calling, into their signals, try to decode that. As I mentioned, they'll try to reverse engineer the IP, get through it without you. Corporate espionage happens all the time, much more widely than is often reported. And foreign powers that have tried to infiltrate the United States have historically been much more successful in corporate espionage than they ever were infiltrating levels of government. Outright piracy happens all the time. I think most of us are aware that artificial intelligence is now being used to circumvent intellectual property. And artificial intelligence now provides a complicating factor of serving as plausible deniability, where you can say, well, look, I just asked ChatGPT to write this story for me. I had no idea. And how was I supposed to know that somebody else already had that story, right? And it's unclear how the courts are going to react to that. And the law has barely even started to evolve around this. And companies will use pretense. They will approach you and engage you in discussions around potentially being a customer, an investor, a buyer, a licensee, as a way of gaining access to information. And they'll engage in that discussion right up to the point where you would ask them to sign a letter of intent that would prevent them from circumventing your business, at which point they said, we're not that interested after all. So thanks for everything. Bye bye. Again, it's nasty stuff that the business world can be bare knuckle brawling sometimes. And I think it tends to be more that way where IP is concerned. Now, before you even pursue the discussion, you have to ask yourself a question. Does the IP have any value to begin with? Because if it doesn't, what are we doing here? And I don't want you to hire me or somebody like me to determine whether the IP has value to begin with. I don't want you spending money on that because you shouldn't need to. Here's a little checklist that you can run yourself to establish whether or not it has any value. And then if you think it does have material value, by all means, bring me to come help you establish some kind of valuation so you can be an empowered negotiator in the market. How has the IP ever been monetized? Even at a small scale, even $10,000 a year. This is something that shows you can find the market for this. Is there an obvious strategic fit? Have you done homework and have identified there's a company that just needs this IP in order to get where it's going to go? And it would be way better off acquiring it from me than it would trying to replicate it. Is there enough reward at the end of the tunnel to justify the risk? We've talked about IP commercialization being an expensive business, a risky business, a long-term business. And at some point, if you're confronted with hundreds of thousands of dollars of investment, are the financial rewards sufficient to justify the risk? It doesn't make sense for you to spend $2 million monetizing IP that's going to make you $1 million. Is there a compelling case that someone is already infringing? This actually is a stealth way of reinforcing the first bullet point. Infringement means monetization. This means that you're not the one who's monetizing it. And that's why we have the court system. So how do you actually go about monetizing intellectual property? I think that there are 6 commercialization models, a few of which I'm sure are already known to you or at least come to mind from a logic perspective, but a couple I think that may not necessarily have been obvious. And the first one, of course, is to launch a business. And the benefit of launching a business, this is the path that gives you the most control and gives you the highest return ceiling. But it also means that you're on the hook for everything and often takes the most amount of time. But if you're going to do it, the steps are these. Develop that business plan, Build a list of customers or channels, fund it, and execute. If you're not sure about how to go about creating a business plan, read Art of the Start by Guy Kawasaki, version 2.0. It's a fairly old book now, but I still think it's a state of the art for formulating business plans. I haven't found one that's better. And funding itself, if you haven't been down that path, could feel like a full-time job. If you have the choice to self-fund, you could raise capital from outside sources. But I want to point out also that there are grants available often for intellectual property, such as the Small Business Investment and Research or Science and Technology Transfer Research. And those funds are available from the federal government. Most universities that do research have somebody on site that is a representative for these grants and others, and you can find other grants as well. They're not the only granting organizations. They're just the two that come to mind. Sell the IP. The benefit to that is that ultimately it's the lowest risk because you're basically handing IP off to somebody else and you're making it their problem. The problem is it's hard to find buyers and licensees. And once you give up the IP, the outcome is out of your control. Now, if you sell the IP and you get 100% cash payment, who cares? But in the likely event that you're going to have a structured payment scenario or an earnout, where you're going to be paid over time and often based on the performance of the intellectual property as somebody else commercializes it, you're going to feel that imbalance of control acutely. First, identify a list of potential buyers and find out who the right contact is. Start reaching out to generate interest, and if necessary, consider retaining a broker. And brokers for IP do exist. Before you hire somebody, make sure that you get references. You definitely don't want to be somebody who is a client of somebody who has a 10% batting average. And for anybody good, expect to pay a commission of 20% of the sale plus a monthly retainer. And the monthly retainer is important because the monthly retainer keeps the broker interested even when it gets tough to find potential buyers and licensees. It sounds counterintuitive. I'm actually a big fan of paying retainers because if you go on a 100% success fee, the deal that gets the most attention is going to be the one that's closest to getting done. And if you're not that super easy deal, you're just going to find yourself always at the bottom of the pile relative to deals that are easier to do. Now, you can also create a joint venture. And this happens particularly with international deals. And the benefit here is you get to share risk and leverage resources with an established partner, which sometimes accelerates the monetization timeline. But of course, when you do that, you're going to potentially lose control. And it can be as difficult to find a partner as it is to find a buyer or investors. You need to create a target list. You also need to do some homework. Why would a partnership benefit them? Why would they be interested? You have to put yourself in their shoes and ask yourself their hard questions. And finding a joint venture partner is going to happen one of three ways. One is you can do it with research, you can do it with networking and conferences. You've got to start learning and making yourself visible in the industry in which the IP exists. Now, with these transactional type monetization or commercialization strategies, there's some common themes that make it most likely that you're going to get a reasonable deal or get the best deal. The first is approach parties that are in the Goldilocks zone. They're not too big and they're not too small. If they're too big, show them the IP. They might say, thank you very much, and then run over you because they can throw money at it. They don't want to pay you the royalty. And not so small that even though your IP would be killer for them, that they can't afford to pay what it's worth. Make sure that you research and vet parties before you reach out to them or take that meeting. Have an idea about valuation. You don't necessarily need to have an exact number in mind, but have an understanding as to what an absurdly high price would be, an absurdly low price would be, and make sure you're not outside that range. Maximize your chance of a successful outcome. Find areas that need to be fixed or shored up, and if you can, fix them. Have documentation ready to go. When you approach somebody to potentially buy your IP or license it or be a partner, and they want information, if you're not prepared, it looks like amateur hour. They'll just think you're not serious and they won't take the conversation seriously at all, or they're going to think you're not very good business person and therefore think they can take advantage of you. So be prepared to respond promptly and crisply to requests for information, and adopt a process like a salesperson. Every day be reaching out to potential parties and add a potential target to your target list, at least one a day. Keep that pipeline full. I don't care how advanced you think your discussions are going with somebody, a deal's not a deal until it's a deal. And even then, sometimes it's not a deal. So how do you vet these potential partners? Google still works. LinkedIn Navigator is a fantastic resource. Here's where the money part comes in. You may want to buy a subscription to ZoomInfo or Paul Dun & Bradstreet reports. I'm not the biggest Twitter/X fan, but I do think that's where that's where you see a lot of the underbelly, or that's where you're willing to see the most negative comments appear about a company for whatever reason. If the company's public, make sure you're reading through their 10K and 8K disclosures. 10K tells you about the company's strategy. 8K tells you specifically about the material deals they've done. Don't be afraid to investigate sources such as Quora or Reddit. You may be able to find something about their IP transaction history through databases such as RoyaltyStat and KTMine. And you can also look up whether they're involved in a lot of IP lawsuits. You probably don't want that. Don't want a partner who tends to be sued a lot. And you can look up in public records whether they're parties or have been parties to lawsuits, as long as those records have not been sealed. There's a database called Pacer that would be a good place for you to start. Now you can also litigate. If you can identify somebody that is infringing and has fairly deep pockets, monetization may come from litigation. That's the entire business model of so-called non-practicing entities, more popularly known as patent trolls. But this is not for the timid. If you don't reach a settlement fairly quickly and you go to trial, you're talking $500,000 at least to pursue litigation, and possibly more until you get a payoff. Now, in terms of funding, there are companies that will provide funding for litigation. They're very choosy, and there are lawyers who will work on contingency. But again, as you can imagine, there's a lot of demand for them. They can be very choosy, and they tend to take only the easiest and most lucrative cases they can find because that's how they make their living. If you do decide to choose to litigate, if you do choose to go the litigation path, here is a checklist for how to choose one. Now, a piece of advice I often give people when they're looking for litigation counsel, or M&A counsel for that matter, is a lot of people like to go for the so-called bulldog lawyer. And that typically means somebody who's aggressive, who tries to intimidate or is intimidating in some way. In my experience, people like that can miss opportunities for success. They can miss opportunities for settlement. For example, when the client is as important as the ego, I don't think that serves the client well. I've seen bulldog lawyers that have hurt their clients more than helped them, and frankly have embarrassed both themselves and their client. Now, no, if you go into litigation, your lawyer is important, but your expert witness, the person who's going to opine, or people who opine on the validity of the invention and the economic damages that you're supposed to be awarded, they're just as important as the attorney. So bear that in mind. Research and development credits. Many states allow people or companies who have invested money in developing something to be refunded, even if they haven't made any money. For the most part, you only pay taxes if you've made money. Companies can still potentially monetize their research and development tax credits. File a tax return that says how much money you spent. The law will tell you how much of a credit you're entitled, and you can either write it off your current taxes, or if you're not paying any taxes right now, you can actually sell that credit to a third party who will then be able to use because they do have taxable income. So it's a way for you to generate income. You just need to gather your expense records and discuss this with your CPA. And I've told you literally everything I think I know about R&D tax credits. Another possibility is to make a tax-deductible charitable donation of your IP. Now, I consider this something of a last resort, but let's say you're not able to monetize your IP through a conventional means, but it may still be valuable. You can then use the value of the intellectual property as a tax shelter, if you will, by writing off the fair market value of the intellectual property. And I have seen this done, in fact, numerous times. I have worked with companies that have gifted the rights to copyrighted material to a nonprofit, and they have secured a significant tax deduction or a significant tax credit. And knock on wood, the IRS has not objected to it. There are some upfront costs of doing that. You have to get an appraisal of the intellectual property. It has to be a qualified appraisal per the IRS rules. And you're not going to get as much for this as any other monetization strategy, but it has the benefit of being fairly plug and play, that as long as your IP is worth something, then you're almost guaranteed to get some value out of it. As you consider your intellectual property, you have to decide, is it worth it? The first thing you should be thinking about is understanding, what is it going to cost you to monetize the intellectual property? Estimate how confident are you that you can successfully do so, that money will actually come back to you? Does that risk return make sense? Give some thought to when your IP is exposed to the market, it becomes a target. Are you able to spend the money that's indicated here to defend that IP? Because if you're not, you may want to rethink. It's not just about the money, but also the bandwidth. It's going to feel like another full-time job. Do you have the bandwidth and energy level to pursue that? And it's okay if you don't, but be honest with yourself at the outset, so you don't waste a lot of time and money on something that doesn't have a high likelihood of success because you can't put everything into it that is required. I'd like to thank all of you guys for hanging in there. And for those of you who watch this in recording, thank you for doing so as well. I've already got one question, so I'll address that right now, which is somebody was asking about SEC disclosures for acquisitions or sales of intellectual property and what's required there. And specifically, is there a threshold at which a disclosure is automatically triggered? Now, I'm going to answer this question not being a securities attorney and not being a CPA, but my understanding is that there is no fixed threshold. SEC kind of mirrors what the accounting world does in that they determine what is material. And material is going to be in the eye of the beholder. When Microsoft buys a company or an IP for $10 million, that's probably not material to them. But a company that is much smaller than Microsoft, they buy a $10 million company, that could be a material transaction and therefore would warrant some kind of disclosure. It really depends on the nature of the company, the size of the company, and what the determination is for a materiality threshold. The publicly held companies, the auditors will tend to operate on the conservative side of materiality, because nobody wants to have the SEC launching an investigation into the company or the accounting firm that did their accounts or prepared their audit report. But in terms of a hard and fast rule, in terms of percentages or something, as far as I'm aware, that doesn't exist. It's purely on a case-by-case basis. I'd like to thank you all so much for attending this. I hope what you found was a good use of your time. Wishing you all a great rest of the afternoon.